Well, a very good morning, everybody. Very warm welcome to our ESMA open hearing on MiFID II. My name is David Lawton. I have either the privilege or the pain of chairing the ESMA Secondary Market Standing Committee and the Commodity Derivatives Task Force, and therefore heavily involved in ESMA's work on the MiFID II issues. I'm joined on the platform by colleagues from the ESMA staff and from other ESMA member authorities, and there'll be other colleagues coming to join us during the day. Thank you very much indeed for coming. It's great to see such a big turnout. It is, of course, testament to the importance of the MiFID II topics. We've got quite a lot to get through today. We've circulated an indicative agenda, and we will break the day up into chunks as we work through the consultation paper section by section. Colleagues will give a short introduction to each section, and then we will open up for discussion, comments and questions, and there will be people in the aisles with microphones to enable you to pose your questions. And as is customary on these occasions, I'd be grateful if you would just say who you are and which organisation you represent before you pose your question. We will break for coffee mid-morning and also mid-afternoon, and then we'll be breaking for lunch approximately between 1 o'clock and 2 o'clock. Lunch, as I think we were told you in advance, isn't provided on the premises, but there are plenty of places out and about who will be very grateful for your business, I am sure. This is a public hearing. It's being recorded by the ESMA staff, and I'm told that it's going to be placed on YouTube later. I don't know what the chances of it going viral might be, but you should, of course, then just be aware of the fact that it is a public hearing and note that as you make your comments. And of course, because it's a public hearing, there may be members of the press present again, so just bear that in mind as you make your comments. Don't think there's anything else to say by way of housekeeping, except that if you are Mr. Carter, you have mislaid your Eurostar train ticket, and you can pick it up at the cloakroom in the coffee break. So the main purpose of today is to, from our perspective, make sure that you have got a good understanding of the proposals in the consultation paper. We really want to make sure that when you submit your written responses, they are as helpful to us as possible. And clearly an important starting point for that is that you have a good understanding of what we had in mind when we were framing the proposals and the assumptions that we have made. So we'd really very much like to hear your comments on the proposals, including things that we would need to take into account or think about in order for the proposals to be workable, or, of course, reasons as to why you think they should be different. This is not an opportunity to comment on the technical advice, which we've already given to the Commission on various aspects of MiFID. That's, of course, now in the Commission's hands, and they, of course, will have a process for enabling further input on that. So we very much want to focus on the consultation paper material that we put out at the turn of the year. If you have been very attentive, you'll also note that we put out a supplementary consultation paper yesterday on the remaining asset classes that we didn't cover in our proposals on non-equity transparency, and we'll also cover that in our material this morning. The second thing that I don't think we will be open to covering today are questions about how we're interpreting aspects of the Level 1 text. Clearly, there are always, with the Level 1 text, areas of uncertainty and a need to reflect on how it's to be interpreted. And of course, collectively, we will need to engage on that as we move through to implementation. but that's not the purpose of today. The purpose of today is very much to focus on the CP proposals. So, by way of introduction, I think we're finished. Let's move straight into the first block of topics, which is around transparency. We'll start with exposition of the proposals on equity and equity-like instruments. Then we will move to non-equity, and then we'll turn to the double volume cap, and then finally in this block, the trading obligations for derivatives. And that may take us to coffee, or we might have a coffee break just before we get to the end there. For those of you that have just arrived in the auditorium, there are plenty of seats down on the right-hand side if you want to come and make your way down now. So our transparency work has been coordinated by Hans Wolters from the AFM in the Netherlands, and I'm going to hand over to Hans now.
Thank you, David. Good morning. I will introduce the equity section of the consultation paper, which is mainly on the pre-trade content, the waivers for pre-trade, the determination of the large and scale thresholds, the content of post-trade, and the regime for the post-trade deferrals. Also, the trading obligation for shares is covered, and you will find the legal text, our proposed legal text, in the draft RTS number 8. For equity, of course, we had the privilege to build on the MiFID 1 content on shares, and had to extend that to equity-like instruments or other equity instruments. Our proposals in the discussion paper proved, I could say, a bit less controversial than the non-equity proposals. So we had, of course, some comments on our proposals, but in general, I think they received a more favorable view from you than our non-equity proposals. However, we have, of course, made several amendments compared in the consultation paper compared to the discussion paper, and I would like to point out just one or two of them and by way of introduction. One of the changes we made in the consultation paper was on the content pre-trade. We added a definition of RFQ as a trading system, and together with the transparency requirements applicable to those trading systems. As it turned out, that quite a few people pointed out that we should include that in the pre-trade content for the trading systems. Another example of where we made a change to our proposals in the discussion paper was for stubs, where we originally had a proposal in the discussion paper for a percentage of the remaining order that should not be covered by the protection of the list waiver, but we changed that proposal so that also with partial execution of the original order, the remaining order remains protected. Then we had also some partial amendments, or I could say further refinement of our proposals in the discussion paper. An example of that is the list of negotiated transactions that do not contribute to the price formation process, where we extended a bit on our original proposal and took your responses into account. Also, the preferred option for setting the ESMA standard market size is where we had originally 3 options in the discussion paper, and now made a choice of option. And another example is the post-trade identifiers, the flags, for instance, where we added a flag for algorithmic trading. So we have changed some of our proposals, slightly amended or further refined, but I must say we have also, of course, maintained some of our proposals in the discussion paper, and I would like to point out just 2 where we also received some comments, but where we maintained our proposals. I think the most important one is on ADT, average daily transactions. as a proxy for liquidity and market impact to determine the large in scale threshold. There was some discussion on that, some comments on that, but as you can see in the consultation paper, we have maintained our proposal for ADT, as we think it's a less complex way to deal with it, and would still be possible to do so. Also, another example is our proposal to shorten the maximum delay for publication of post-trade information, where we propose in the discussion paper to reduce that from 3 minutes to 1 minute. There was some support for that and also some opposition in the consultation paper. Now we have maintained our proposal to stick to 1 minute, so to shorten this delay. Shorten this delay for the publication of post-trade information. The questions you see in this section of the consultation paper mostly ask whether you agree with our proposals or whether you have different views. I must say in one or two instances we have also not yet put forward a position and ask for your view. And an example of that is whether a systematic internalizer should include a timestamp in the pre-trade information. So if you agree, David, I would leave it here as my introduction and be happy to take your questions and views on this.
Thank you very much indeed, Hans. So we're looking at draft RTS number 8. It's covered by sections 3.1 through to 3.4 of the consultation paper, and it's the equity and equity-like transparency proposals. Also, this is building on a regime which already exists under the current MiFID. So much of the building block superstructure is pretty familiar. So who would like to offer a comment on this, please? Raise your hand very clearly. Because the lights are very bright on the platform, it means that the audience, from my perspective, is just slightly bathed in gloom. So you really do need to stick your hand up and wave it around pretty vigorously in order to be able to be seen. And we have microphones in each aisle, but just in order to speed things up, I might alternate between aisle to aisle as we take questions, so as to enable the microphones to find people quite quickly. So who has a question to start with? Who's going to be the first person? Somebody right in the front, on the right-hand side at the front here.
Thank you, Dietrich Lange, BBR, National Association of German Cooperative Banks. A short question with regard, in general, to transparency, to the cost-benefit analysis. As you know, there are some missing parts really relating to the core topics of market transparency. My question is, when will they be put into your deliberations, and will this be public? Is there any chance to react on this cost-benefit analysis with regard to market transparency and also for other parts? Thank you.
Thank you. Actually, that's a good question. And Rodrigo Buenaventura, who's the Director of Markets at ESMA, has been taking a leading role in the arrangements for the cost-benefit analysis process. And actually, probably that's a good cue for him to say a few words more generally about the CBA, and then particularly to your point about how it picks up the market transparency elements.
So the usual practice in ESMA is to deliver a cost-benefit analysis, and that is not only a usual practice, it's also a legal requirement at the time that we deliver the standards to the European Commission, and to make that public, of course. That's what we always do. In some occasions, like this one, where there are some new provisions or some elements that change quite a lot the market practice, we aim, whenever possible, to publish a high-level interim draft cost-benefit analysis, which is not a full CBA, but is just some indications of what are the main costs and benefits of the measures. That's what we did in December, and of course, being MiFID a quite large project, we were only able to cover certain sections, and we concentrated on those that were changing or were to a certain extent new in terms of the regulatory scope. So what we will do is we will produce a full cost-benefit analysis that will be delivered together with the standards before July is the date that we have now. And unfortunately, we were not able to cover all the sections in that interim high-level version, which I would insist is not always, if you look at the ESMA consultations, available in the consultation paper.
Question over on the right-hand side. Thank you.
Arjun Singh Michel from the Investment Association. A question about large-scale post-trade transparency. I was wondering, the analysis within the consultation paper did not make clear the justification for dividing up the trading day at 3 o'clock for the purposes of the large-scale post-trade rules. I wondered if you could perhaps clarify as to the justification for that and whether there was any data work that went behind that.
Thanks very much, Arjun.
Well, the rationale behind is that late in the day it would be it would be very difficult to do that before the end of the day. So we give some allowance there for later publication and before the start of the next trading day and in the early day. In the next trading day, but whether it should be 3 o'clock, 3:15 is maybe arbitrary. But we thought the last 2 hours of trading, last few hours of trading, there's some rationale for a leeway there. Not sure whether anyone would like to add to that.
Okay, thank you. Another question at the front here, please.
Christer Wernerberg, SEB. I have a comment regarding identification for post-trade reports. And I think it's very important that the flags that can be set by the venue is set by the venue and not the investment firm. That will reduce the risk of erroneous input and also reduce the cost for the investment firms to have records of what stocks are liquid or illiquid. I think that's also opens up for dividing the 1 or 3 minute rule to have a 3 minute, keep the 3 minute rule for the more cumbersome trade reports and use the 1 minute rule for the more standardized trade reports.
Thank you. Question down at the front on the right.
My name is Bauer, a German savings banks group, speaking for the German banking industry committee as well. I have a follow-up question to Mr. Buenaventura. You just mentioned a high-level cost-benefit analysis in December. I just wanted to ask the question on in which countries and who were the participant of this high-level cost-benefit analysis in December?
So the cost-benefit analysis is in principle addressed at the whole European Union, but in some aspects of that report, we did some data gathering of certain samples, and we had to do samples because it was not, of course, feasible to do in-depth data gathering for that high-level report for all the 28 member states. So we did a sample of 12 member states that was configured with small member states, large member states, different geographical zones, and also sizes of the financial markets. But that is just an initial approximation, and what we are doing now is conducting, as I said, a full cost-benefit analysis, not a high-level one, that we are aiming at gathering as much data as possible. What we are also intending to do in the next, well, it was going to a few weeks, but in fact starts next week, is to launch a questionnaire on a number of topics that we did not cover in the first high-level report, and that would address all the remaining parts with a view of completing the CBA by July.
I think that the goal of this next round of the process is to try and ensure that the data that we're gathering and are using for the CBA is a representative sample both across geographies and different types and size of market participant. I think that's an important goal, isn't it, of the next phase of the data collection exercise. Any other comments on the equity transparency? In the middle at the back, please.
Thank you, David. Andrew Bowley at Nomura. In equities, there's a number of transactions where there's asset class switching, which includes exchange for physical, creation and redemption of ETFs, switches into DRs, and also equity trades that roll into equity swaps and CFDs, which of course have more relevance following yesterday's paper. The DP had a list of 6 areas and included specific items on these around negotiated trade waivers, but the list has been reduced now. Do you see that creates more uncertainty, or is the intention to just broadly capture all of those scenarios?
So this is a question about which transactions are outside the scope of the transparency regime. Yep.
Correct, yeah, for negotiated trade waivers.
We have tried to make an exhaustive list there that builds on the list that we proposed in the discussion paper, but to our extent should be sufficiently flexible. And I think if you have some specific comments on what you think is still missing there, that would be very useful to see in your consultation response. But we have tried at least to incorporate and weight the comments, and also so decided to make it exhaustive, but to our extent sufficiently flexible to adapt to market circumstances.
So just to be clear, we have not tried to deliberately narrow the range of transactions which are on that list, but just to write the list in a way which is more accurate. I
would have to check the exact content of the list there, so that's also why I asked. But if you really think anything is missing there from our list, that should be included there, that we overlooked one of the responses, that would be very helpful. But in general, we have tried to present it in a bit different way. That's true.
Okay, thank you. Question in the middle here, please.
Thank you. Mark Frith, HSBC. 2 questions, if I may. One is on the non-price forming events. Would there be appetite to include intragroup risk management trades that don't just contribute to the price discovery process? And secondly, for market abuse purposes, ESMA has to produce a golden source of instruments traded on venue. Could firms rely on that for MiFID purposes as well?
Thank you very much, Mark. Who wants to take those 2 questions? I should have said at the beginning, there are bound to be some questions that stump the panel, so it's good to get the first one on the table early, so we're not unduly embarrassed later. I mean, the scope of the MiFID project is such that whilst we're all doing our best to, I'm sure you are, to keep it all in your heads, there are always 1 or 2 little elements that just slip from the front of the mind, particularly when the lights are shining on you.
On the second one, on the list, we are building, in fact, the 2 lists, and if you have looked at the RTSs in MAR and, the regulatory technical standards, in MAR and in MiFID, we are trying that the information, the reference data for the financial instruments is compatible and that it will ultimately constitute 1 list. Having said this, you need to be aware that the list that ESMA keeps is for informative purposes, but it doesn't mean that if an instrument is not there, I'm speaking mostly about MAR, is not subject to MAR, because the scope of MiFIR is not determined by the ESMA list, but we are indeed working towards a single list that can serve both purposes. That's the overall idea, yes.
Intergroup transactions? Something to think about, by the sound of it.
We'll look into that.
Something to think about, Mark, thank you. And again, that's a good example of what I said at the beginning. One of the benefits, I think, from the consultation process, from our point of view, is to hear back from you about things that we need to think about, that it's not evident we are currently thinking about in order to make the proposals work or complete. So thank you very much for that type of question. Any other questions on equities? On this side, please, at the front.
Yes, Emmanuel de Fournou from MiFID. Yeah, I've got two questions about the list on transaction not contributing to the price discovery process. Sorry. The first one is you define portfolio trades that involves the execution of 10 or more shares, and in the discussion paper, I think it was more than one, and I don't understand why it is more than 10 today. The second question is related to the transaction of a transfer for the purpose of transferring financial instruments as a collateral. Why did you put segregated collateral? You can transfer collateral which is not segregated.
Okay, thank you. Two quite detailed questions there.
Yeah, on the first one, I think we made there. I don't remember that if it was just more than one in the discussion paper. It would seem a bit large diversion, but it's more than 10 in the, like you said, in the RTS, and we thought that would be at least at that point. You're sure to be to have a portfolio trade. And the second one, I would think it's rather detailed, so I would like to check that.
So that was about why we referred to segregated collateral rather than just collateral. Question at the front here. Thank you.
Frédéric Bonpère, Amundi. My question relates to the ETFs. Apparently, ESMA understood that ADT was not that good way to an appropriate criterion to define the liquidity of ETFs. And for pre-trade transparency waivers, ESMA does not refer to ADT. But for post-trade delay in publication, it still refers to ADT. Is there a reason behind that?
Okay, thank you. So obviously ETFs are brought into scope by MiFID 2, and obviously we then have to think about how to set the regime for them. And obviously the discussion has really been around, should we focus on their characteristics as ETFs or have some regard to the characteristics of the underlying? Actually, Carsten Osterman is going to pick this up. Carsten.
Thank you, David. I think we are still using ADT, generally speaking, for ETFs, where we're not using it as, to determine the standard market size, because that is the so-called AVT as per the level 1 text. But on ETFs, the discussion we had was exactly what David was saying, that should it be based on the liquidity of the actual ETF or based on the underlying, and that's the two options we have out there, basically.
Any final questions on equity? I can see two more. There's someone in the middle of the back, and then someone over on the left-hand side.
Thank you. My name is Elina Yrgård, and I'm from Nasdaq. I have a comment rather than a question, so whether you want to reply or not, it's really up to you. But it's about the systematic internalizer. And we were among those stakeholders who, as you have put it, urged ESMA to clarify the ambiguities in MiFIR regarding whether the systematic internalizer could do multilateral trades, or to which extent, to clarify between bilateral and multilateral. And we do note that ESMA does not feel empowered to say anything about it, but we anyway wanted to underline the importance of working on clarifying this somehow. There hasn't been so many systematic internalizers so far under MiFID 1, but it's easy to understand that there will be more under MiFID 2, and all the ambiguities in the regime are worth clarifying. So we wanted to reiterate that. Thank you.
Okay, thank you. I mean, your comment is noted. Carsten, you want to?
Yeah, just to quickly react, I mean, we have noted that. We have put it into our technical advice to the Commission. I remember that was paragraph 27 of that particular technical advice. We're already going beyond our mandate, I suppose, and, you know, clarifying that kind of point. But the rest is then over to the Commission, who is in charge of the delegated act in that respect.
And I think there's a question over on this side.
Thank you. Richard Gardner from the Federation of European Securities Exchanges. Just 2 quick points. The first one is on the request for quote systems, and we take your point that there was a lot of stakeholders in the initial round calling for this, but we do see a difference between the equities and ETFs in this sense. And the equities side, I suppose a quick question and a comment about, have you seen how this may actually interact with the current market structure and perhaps challenge what is the kind of multilateral and bilateral structure we have now at the moment? So that's the analysis we are doing. So it's a question to ask you, and maybe for you to look at further about how this could challenge the kind of multilateral nature of exchanges at the moment with this perhaps hybrid system coming in. And a second comment is on the exhaustive list for the trading mandate. I mean, we very much support the fixed list. We think that being a more legally secure route to go down, but we would urge ESMA to look at tighter definitions of certain trades in there, such as benchmark, portfolio, and delta neutral trades. And that's some input we'll be giving to highlight it here. But we think that's going to be key to really nail those definitions to ensure there's no loopholes and no circumvention that would follow up in the volume cap discussion we'll probably have later. Thank you.
Thanks very much. Richard? I'm keen to move on to the next topic if there are no more questions on equity transparency. Okay, thank you. I think that's warmed us up very nicely for the discussion on non-equity transparency, which I suspect is more challenging and more controversial. So this is draft RTS number 9 in the CP, and it's covered off in the discussion in sections 3.5 through to 3.9, and in substantive terms, obviously it's a huge chunk of the markets aspects of the consultation, if you add in all the tables. As I said in my opening remarks, we have supplemented the first CP with an additional CP that was published yesterday with proposals for the final 3 or 4 derivatives classes that we didn't cover off in the first CP. And I think Carsten is going to introduce this one. Carsten.
Thank you, David. Indeed, non-equity, of course, is the crown jewel of our standards, really, which I think is about 400 pages roundabout, or close to 400 pages in the consultation paper and technical standard alone. On top of that, as David just said, I think we put another 300 plus pages out there yesterday, which cover then credit derivatives, CFDs, what else have we in there? FX derivatives, of course, and other what we call exotic under C10 of MiFID. And there the consultation deadline is the 20th of March. So if you're concerned about getting bored with responding to MiFID papers and tight deadlines, do not despair. There is more out there. And in that context, also the cost-benefit analysis, which was already mentioned earlier. Of course, that is, on the cost-benefit analysis, we have to pick and choose a bit, but of course, non-equity is extremely important, and then we're going to make an extra effort, and you're going to see there, sort of roundabout end of February, we're going to put out a number of questionnaires on the CBA, but in particular on non-equity, we have put together quite a template, and I'm sure you're going to have fun with filling that in. And again, the deadline there will not be too generous, I assume. That by way of introduction then, since this is a huge topic, we're going to divide that up between a couple of people. I would start with liquidity and the liquidity concept, which is, of course, very important in the MiFID context. Liquidity basically divides up the instruments between those that have real-time transparency versus those that don't. Still, the liquidity on the pre-trade and the post-trade side is a waiver or a deferred publication, so it requires first approval by each competent authority, which is an important point to take into consideration. On liquidity and also later large in scale, we have made a huge effort in terms of analyzing data there and capturing all the asset classes really. And what we have done there, particularly on derivatives here, is for most of them that are already covered in this consultation paper, that is based on regulated market or trading venue data, I should say. And on interest rate derivatives, this is based on trade repository data, and also the new consultation paper will mostly be based on trade repository data. To maybe structure the discussion, I would start off with fixed income, and we would invite comments for that. On fixed income, what we've done for liquidity is we have picked the COFIA approach, so the classes of financial instruments approach. We are well aware of the downsides of that approach, and I think we have been very transparent about it in saying that it is a static approach, but also it is not 100% correct, and we have the table on page 104, which gives you exactly per class there the false positives and false negatives that occur by applying this classes approach based on the issuance side as basically the dividing factor, the indicator for dividing between what is liquid and what is illiquid.
So let's break it down into chunks then. So as Carsten said, first element of discussion is the approach that we have taken to, firstly, defining liquidity, because that is obviously something that is not itself concretely in the level one, and then secondly, how we've embodied that in the COFIA approach for fixed income, which, as Carsten says, is an approximation. It has some attractions of simplicity of application, but it has clearly some downsides in terms of not capturing completely accurately the instruments that would be defined as liquid on our parameters. So comments and questions on that? I'm sure there are some. Lady in the middle, please.
Hi, thanks. Elizabeth Callahan from ICMA, International Capital Market Association. Really my thought first is sort of the thought process around liquidity and determining liquidity, so it's sort of a two-parter. First one is, why are trades below 100,000 excluded from the calculations when corporate bonds often are, certainly the medium corporate bonds, around 150,000 or sometimes below 100,000. We were very surprised to see that. And secondly, really, again, the thought process and thinking around how something that trades twice per day is considered liquid. If you could take us through that, that would be very helpful. Thanks.
Thank you. Thanks very much indeed, Elizabeth. Carsten.
Well, 2 trades per day. To be honest, we want to be demanding on this, and we want this to have an impact, of course. And I understand, of course, we can always discuss about the figures there, but the outcome of this certainly cannot be that what is already transparent at the moment remains transparent, and for the rest, everything remains the same. And if you look at, just applying the 2 trades per day, and it's not just 2 trades per day, but it is applied in a cumulative fashion, so it also needs to have the minimum trading volume per day and the traded daily roundabout. We're only capturing around about 3% or so of the entire market, which is in terms of instruments already extremely small. So therefore, this is our proposal, but always happy, we're hearing this a lot, this is way too low. If you have a counter proposal based on factual evidence, very, very happy to listen to that. And the below 100,000 on the bond market side, we did the calculations there, and of course there are many small trades. We have taken that out, I think, for fixing then the block sizes, because we were arriving at sizes which were, extremely low. But happy to, take that into consideration. Like I said, we're doing the cost-benefit analysis on this, and we'll, hopefully get more factual data on that basis. In our template that I was mentioning beforehand, we're going to pick quite a number of ISINs on the bond side, where we're then asking about trading patterns. And from that, then we may be able to get closer to the truth of, where we should set those values.
Thanks very much, Carsten. Rodrigo also wants to come in on this. And just one supplementary point from me. As Carsten was indicated, one of the things that we have been having an eye to, as well as what you might think of as the micro parameterization of the regime, has also been to step back and ask, at the macro level, what proportion of instruments and what proportion of transactions would be within the transparency border, because we think that is something that the legislators will particularly want to probe.
Yes, I wanted to supplement what Carsten said, because this concept of liquidity is a central one, as you said, in the whole regime. But I think it's important, even if we are tackling it before the other elements, we consider it in the sequence of the different, let's say, protections or the different mechanisms for transparency and real-time transparency especially. I think it's important to bear in mind, and we tried to put that in the consultation paper, that our approach here is not to discuss or to try to define what is liquidity as an abstract, absolute concept, because you have plenty of EU regulations that deal with liquidity. And we tend to see this as a discussion or a definition that is adapted to the purpose. In this case, is liquidity for the purposes of transparency. You will find other definitions of liquidity in other regulations. For instance, if you look at the implementing regulation of CRR and what is considered liquid enough, or what is eligible for monetary policy, or what is eligible for clearing, or what can be used as collateral, you have different ranges. So we are not trying to redefine liquidity as an absolute concept. And of course, these threshold of 2 trades a day, there are many bonds that trade way less than two times a day that are nevertheless considered liquid for other purposes, the ones that I referred before. So I think it's important that we don't try to define in abstract term what is liquid. We need to define what is liquid for the purposes of being transparent, and therefore having in mind also the large scale and the size specific to the instrument that will be discussed later. I think it's important to have that in mind for the analysis of the proposal.
Thanks very much indeed, Rodrigo. That has prompted quite a number of hands to go up now. So let's start in the bottom left-hand corner. The lady behind first. Thank you.
Thank you. Dorrit Bokelmann of the Association of German Banks. I have a question concerning Table 5 on page 104 of the CP. It shows ESMA's segmentation assessment. If we look at EU sovereigns, we see that out of about 3,800 bonds, roughly 500 bonds have an issuance size above 2 million, plus they meet those 3 criteria that you have defined. There are another 367 bonds above 2 million euros which do not meet those 3 criteria. Nevertheless, ESMA qualifies them as liquid too. We'd call them false positives, and they make up for about 40% of all so-called liquid bonds. Now my question would be, why does ESMA think this hit ratio is acceptable? We'd call for a ratio of at least 95% and ask ESMA to choose eligible parameters in order to deliver quality results for Europe's market. Thank you.
Okay, thank you. I think that's more of a comment than a question, but I think I think the schema that is outlined in the consultation paper, as Rodrigo and Carsten were saying, explicitly acknowledges that the COFIA approach is an approximation, but then says you can potentially address some of the consequences of that through the levels at which you set the thresholds thereafter. And I guess the question, one of the core question that we're asking in the consultation is that whole construct workable? Maybe it needs some adjustments to the parameterization, or do we need to take a different approach? If you remember back in the discussion paper, we talked about instead of doing the COFIA approach, we would do what we call the instrument by instrument or IBIA approach, which of course would much more accurately capture individual bonds as to whether they were liquid or non-liquid by the metrics that we had set for what counts as liquid.
Thanks, David. I think you're absolutely right. And like I said in the introductory statement, there are downsides to this, and we have been transparent about it. And in this table, we call that false positives as well. We'd love to have an approach which is 100% correct, but unfortunately, the world is not like that. We don't have the data available, the indicators available. So if you have an approach that gets us above the 95% mark, again, very happy to look at it, but also we are certainly going to try to refine this further ahead of the final proposals.
So I think there was a question on this side, and I'll come back to this side. Who was on this side? The question. Arjun.
Thanks. On the definition of liquidity, Liz from ICMA raised the issue about changing the liquidity criteria insofar as the number of days traded are concerned. I think on the buy side, we don't necessarily support that view. We think that the liquidity criteria can largely remain the same. Whilst we still have concerns about the actual criteria itself, we think that the COFIA approach can be made to function more accurately by simplifying it further. Rather than having 9 COFIA classes, simplifying the COFIA classes, bringing them down to 6, and then reflecting appropriate issuance sizes that would optimize the accuracy, and then applying ESMA's existing liquidity criteria framework onto the reworked COFIA classes. So whilst I think on the buy side we have concerns about the threshold set as far as the criteria to determine liquidity is concerned, we still think that it can be made to work, and that the COFIA approach, if simplified further, can be made to work and can be made more accurate.
Okay, thank you. Obviously, we'll be interested in seeing more details about how you think that simplification could work. Question down in the bottom corner, please.
Dietrich Lange, BWR. In the same line of argumentation, we think that if you take COFIA, there should be some refinement as with regard to having a permanent trade in the focus of your liquidity definition. We think, as all your graphs show very clearly, that in the first, let's say, 4 weeks, there's if at all, a trade in after the issuance of a bond, there might be some trades. It's always a curve like this. And if you take this into account and let's say to not have under consideration the first 4 weeks of trading, then you might come closer to a concept of a permanently traded ISIN, I think. This is our proposal. Thank you.
Okay, thank you. Again, keen to see more details of that in your consultation response. So 2 questions in the middle, one at the front and one at the back.
Hello, this is Miranda Morad from Trax. We have done a fair amount of analysis on the ESMA proposals, and most of you are familiar with our work. We agree that the approach of COFIR or even IBEA does not attempt, nor will it ever achieve, the definition of true liquidity, which we think is more something in the lines of your ability to execute or ability to trade in size. We don't think that either IBIA or COFIR will achieve this, and we hear you when you say that your purpose is to define liquidity for the purpose of transparency. However, I submit that it's not possible to divorce that purpose from the harmful effects of imposing real-time transparency on trades that are actually illiquid. And so looking at the tools that you have, which are your LIS and SSTI waivers, and also the information to be made public on an RFQ where those trades will likely trade if traded electronically, we urge you to go for a tolerance level, to seek your tolerance level for misclassification, and accept that this might result in a significantly lower SSTI waiver than the ones proposed. Our data analysis will provide you with the relevant information to help you analyse that, but ultimately it will depend upon whether or not you're prepared to prioritise the damage of misclassification or false positives from the risk, and the risk of making those trades subject to real-time transparency, whether or not you're prepared to prioritise that over what is politically acceptable as a capture rate.
Okay, thank you. I think that's what you're saying is it's really important to get this right. I think we would agree with that. Question 3 or 4 rows behind.
Yeah, good morning. My name is Brett Chappell from Nordea Investment Management. The clients who have given us money to manage, every month we have to sign out on a relative liquidity score. And if this data is erroneous, where we could come out and say for this fund that we have, a mutual fund, we've assigned it a liquidity ratio of 80%. But if there is a 10% withdrawal in that fund, and that's our client's money, and it turns out that we've promised them that these are liquid instruments, but they're trying to get out, it's going to prove to be very, very difficult. I think that this is an unforeseen consequence of going for an easy solution. And it's not meant of any criticism, because I know it's not an easy case. But finally, for the people, the pension funds that have given us money to manage, we would be bold-faced lying if we were to apply an 80% liquidity score, when in actual fact, by using certain aspects of the COFIA, which are simplified, in my opinion, than otherwise. And one other comment, I think it's very important to point out, liquidity, in my world, does not equal transparency. They are two very, very separate entities. Thank you.
Okay, thank you. I mean, I think the point that Rodrigo made a few moments ago, that clearly there are multiple references to liquidity across European legislation, and in this context, we are simply using it as a definitional building block in order to drive the transparency regime. It has no formal implications for any other aspect of how provisions should be applied. It's purely for the MiFID transparency regime, and in a sense, once you've devised the regime, it falls away. It's a bit of scaffolding that gets taken down. Question right at the back. In fact, 2 questions right at the back.
Hi, Caitlin McAlane, Sidley Austin. I'm here with the Managed Funds Association. I think the general feeling was that the tables that are set out at Annex 3 are pretty simple to read and apply in practice, but our question was whether they really need to be built into the regulatory technical standards. And obviously, we don't want a situation necessarily where parameters are changing constantly, but building the tables into the RTS necessitates any change going through the process of approval by the Commission, the Parliament, the Council. So we felt they may be too static, perhaps.
It's a good lawyer's question. Rodrigo. Across the piece of developing our advice on the RTS, we are faced in a number of situations with this challenge of how do you specify the RTS in a way which builds in as much ability to adapt to changing market circumstances as possible and doesn't rely on having to go back and change the legislation whenever you need to make a change in key parameters.
I think the short answer to your question is yes, they need to be there, and they need to be in a regulatory technical standard because that's the instrument that the legislators have given us, and no other to determine this. I think it's important, as Carsten was saying at the start, that there are two steps here. ESMA is defining the harmonized conditions applicable all across the EU for the application of the waivers on transparency, and then national competent authorities will need to take a decision on those waivers. But when they take a decision, that will be based on the conditions defined in a harmonized manner in an EU regulation. So we are fully aware of course, the reason for this is legal certainty, no other. But we are fully aware of the limitations of having certain tables that might be subject to change because of the market structure or the liquidity changes in a legislation, in a regulation. But that's the only instrument we have. And you're right. There is a process that you could calculate in around 9 months, if everything goes well, of amending these. It is true that probably this is especially acute for this type of instruments because we haven't had that many changes in the MiFID I tables that lasted for 7 years so far. So in some might be pretty stable, but yes, in some we might need to review them if we see that the consequences are not the intended ones. But that's the only legal tool that we have. Yeah.
There's a question right on the back row. I want to move on reasonably soon to the other aspects of the non-equity transparency element. So I might just take one or two more questions on the liquidity approach and then move on to some of the other parameters because they're important. We have some time to discuss those too. So, question at the back.
Hi, this is Sid Olka from AFME. I have a two-part question. So first of all, it was mentioned that the weaknesses of the COFI approach would be addressed in the SSTI and large-in-scale regime. Is there anything specific that ESMA has done in that regime to take account of those false positives? Because there was nothing expressly in the consultation paper. And second, how did ESMA derive the 50% of LIS for SSTI? Again, there was nothing expressly mentioned as a methodology in the consultation paper.
Mm-hmm. Okay, thank you. Sometimes parameters just appear. Carsten.
Thank you. We haven't addressed the false positives, particularly via or on an instrument basis in the LIS or size specific to the instrument. I'm struggling to think how we could do that. I think more the approach is, well, there is the liquidity concept and there are other safety valves to transparency, these being large in scale and size specific to the instrument. We're trying to structure it in that particular way, and size specific to the instrument is only available under certain circumstances. And then the idea of addressing it, that we have false positives in there, would be on the sizes then of the particular of the two waivers. On the second point, on the 50% SSTI, well, you are aware we're dealing with an extremely complex level 1 text here, and this is just our way of operationalizing this in a matter that can work in practice and that people can understand. I think if we would have different methodologies out now for large in scale and SSTI, it becomes extremely difficult then to apply that in practice.
But certainly one comment that's been made in this discussion is whether we might look at what proportion of trading lies between the 50 and the 100% and the 0 and 50, and whether that is an even split or not. So that's certainly something we can look at if we continue with this structure. Final question on liquidity, and then I want to move on to the other aspects of non-equity transparency, because otherwise we won't have time to finish those. Apologies for those that have raised their hands. I won't have a chance to come to you, but final question on liquidity.
My name is Kirsten Hermanson. I come from the Swedish Securities Dealer Association, and I also represent the Nordic Securities Dealer, and is also working somewhat for European Banking Federation. I would like to come back a little bit on the question that was raised under in the hearing in the summer, the step-by-step approach. If that is, we learned you can change your mind. You can go into, you can change the rules within 9 months, if I understood it correctly. But would you also consider, when you set your rules, that you could actually move upwards? I mean, there are large concerns about the methods that you now have proposed from all angles. Hopefully you will find a good solution, but we're not really sure, neither of us, I suppose. So how to deal with the uncertainty, if I may put it that way. Thank you.
I think your question was around how do we build in flexibility to adjust the approach if we need to. Okay.
And I could add, we talked to the Commission in relation to the Delegated Act, and they said we can always change our minds. So this is, we will not promise anything, but we can always change our mind whenever we think is appropriate, and we will keep our eyes open.
I mean, the question with any RTS, of course, is that, of course, minds can be changed. It's the question of how long it takes to deliver a new RTS.
Well, we have tried to build in flexibility to the extent possible, say here on the large and scale SSTI calculations with our 70%, 90% approach, which are our conditions then, which would only be in the technical standard, and then we would categorize the instrument on that basis. I think that's the sort of maximum flexibility we can build into the technical standard while still, remaining within the empowerment that we have. On the point on, us changing our minds and the uncertainty that creates, I can assure you I have no intention of doing all this every 9 months in a perpetual circle. So, therefore, if that gives a bit of certainty, for us, that just wouldn't be possible to continuously, particularly revise this technical standard. It would be there is something major, and then we would open it up and then change the various thresholds.
If anybody is interested in doing it every 9 months, perhaps you could come and see us in the coffee break, and we can see what we can fix up. I want to move on to the other aspects of the non-equity transparency regime. We talked about the large in scale and the size specific to the instrument thresholds. Carsten, are you going to introduce this?
Yeah, I'm maybe very quickly then talk about pre-trade and the various trading models that we are proposing there. So basically the approach we've gone for is we define various trading models and then say what kind of transparency has to be provided in there. I think the main concern there is certainly on voice trading systems, which are explicitly mentioned in level 1, so they are covered, but the very practicalities of being able to provide, well, particularly pre-trade transparency, but also post-trade transparency. The other one are RFQ systems, where we hear a lot of concerns that this is going to be the end of RFQ systems as they exist. The thing is, I said that to many people. I think we have very little leeway in really, doing something different to what we are doing in the consultation paper, because the level 1 text says, notwithstanding the recital on you have to calibrate and so forth, we are of course aware of that, but it says, quotes have to be made public. So happy to listen to creative proposals there or what to do. But so far, I haven't really heard much. And with that, I would maybe hand over to Charlotte to go to the post-trade side.
Yes, so to quickly go through the post-trade parts. So we define the content of details to be made public, as well as quite a number of flags. We also specify the maximum permissible delay for publishing post-trade information, trying to take a pragmatic approach here that we suggest to use 15 minutes for the first 3 years before moving to 5 minutes. For the deferred publication system, which is subject to approval by the competent authorities, well, you know that we have 3 kinds of waivers: large in scale, SSTI, and instruments with no liquid market. Our proposal is to provide for deferral of 48 hours across the board for the sake of simplicity. For the calculation of the LSI and the SSTI, we suggest to calibrate the SSTI as 50% of the large in scale. We propose 2 options in our consultation paper on whether to go for a static system where we fix the threshold in the RTS itself, or to go for a dynamic approach, which would be our preferred option, where we would only set the threshold for the first year and then reset them annually based on a calculation. So that would allow us for some flexibility and avoid running the risk of doing the RTS on a yearly basis. Now to the last area, there's also the possibility to supplement deferred publication with additional features by competent authorities. We can roughly distinguish between 3 cases. So there's a possibility that the national authority requires additional limited info during the 48-hour deferral. So this could be either the aggregation of the transactions or to require that everything be published except of the volume. The second case could be that you allow an extended deferral period of 4 weeks. There we can also distinguish between 2 cases, aggregation of transactions or volume omission. And the last scenario we have is for sovereign bonds, where the aggregation of transactions can be deferred for an indefinite amount of time. And I leave it here.
Great, thanks very much, Charlotte, and thank you very much, Carsten. So again, quite a lot of detailed material in this section of the CP. Much of the discussion, obviously, that we've had this morning has been very much around fixed income, and certainly in the conversations we've been having more informally since we put out the CP, a key focus has been on fixed income. It's clearly important, but there's a lot of material in the CP that's covering derivatives. So please do scrutinise that and give us your feedback on that, because that's a huge amount of material. Let me open up for questions and comments on the other elements then of the non-equity regime. Somebody very enthusiastic already in the middle here, please.
Yes, thank you. Elena Yrgård again from Nasdaq. And as you said, maybe I mistakenly understood that we were talking about fixed income previously regarding the liquidity. I wanted to mention something about equity derivatives in relation to liquidity. I hope that may be okay. For equity derivatives, we do believe that the option 2 is better. We support that because it also helps preserve current levels of transparency, because there is a lot on equity derivatives. However, we understand that the analysis that ESMA has made is quite rough cut, and it doesn't cover. It would have different results if it would cover other markets. And we're hoping to be able to provide you with something that shows a little bit different picture. And one thing we would suggest would be to look at sort of product classes and looking at the underlying and whether there is actually liquidity in the underlying as well. We think that would improve the model, because there should be room for improvement there. Thank you.
Okay, thank you. Other questions, please. Question 2 rows back.
Thank you, Andrew Bowley at Nomura. Perhaps to bridge the topics, one of the challenges we have is packaged products across cash and derivative instruments, often that may be priced based on a delta between the two. Could you explain how ESMA anticipates packaged products to fit into the pre- and the post-trade transparency regimes you just described?
Thanks, Andrew. That's a good example, again, of what I said at the beginning. It'd be really good, not just today, but in the consultation responses, to have flagged to us things that we need to think about in order to make sure that the regime is properly calibrated, and things that we need to think about to make sure that we apply it in a way which captures everything. Who wants to pick up that question from Andrew? Packaged products. Okay, maybe it's one of those things which add to the list of things to think about. A question right at the back, and then a question down at the front here.
Thank you. Maximilian Lück, Deutsches Aktieninstitut, the Association of German Listed Companies. I have a question regarding derivatives used by non-financial companies for risk mitigating purposes. We think, since they are not traded, on a secondary market and there is no investor involved who should be protected, we think these kind of derivatives shouldn't fall under the transparency requirements. What do you think about that? Thank you.
I suspect, and I'll look to my colleagues, I suspect the key to that question is whether the level 1 allows such instruments not to be covered.
This would be a level 1 discussion because this is the exception in level 1. So I mean that certainly we need to look at it later, but not at this stage.
Question down at the front here, please. And then there's one in the middle, I think, as well.
Thank you. Thank you. Lange BBR. Relating to the 48 hours, the deferral period, a practical proposal, I think one should take into account the normal trading hours. Otherwise, a 48 hours deferral period, which would commence on, for example, Friday evening, would expire on Sunday evening. This would obviously not provide sufficient time for the, for example, SI to unwind large volume transactions. So our practical proposal is to have a T+2 rule, as in other, like for example, settlement efficiency, settlement periods also. And in the T, transaction day in target days, this would be much better, we think. And in addition, it should be some default periods for larger periods for bonds for 2 weeks, I think, in addition also. Second proposal is with regard to the SSTI threshold. This means the size specific to the instrument. And we think it's an unspecific size to the instrument if you say it's 50% of LRS. What politicians wanted on level 1 was an SSTI related to the retail trade, we think, and it's in a milestone in the level 1 text, I think. And for this reason, we think it's not possible to have a fixed relationship between both measures. Mm-hmm. Thank you.
I think it's fair to say that we have struggled somewhat to really make sense of the level 1 text in all respects, which is not to say that it doesn't make sense, it's just that we haven't found that sense yet. But so when you're with the if you remember in the discussion paper, we were not particularly clear about how we saw the SSTI concept working, so we put a relatively straightforward proposal out in the consultation paper, but we recognise it's not the only way of handling it. A couple of questions over on this side, and then I'll come back to the middle.
Thank you. Helle Thyssen from the Danish Security Dealers Association. That's for the SSTI. We have some questions here. It should also reflect the retail size. I'd hardly think for covered bonds that 2.8 million euros reflect retail size. And in Denmark, the covered bond market is very important for the housing. So we think it would harm the covered bond market very hard. So how do you think to incorporate the retail size?
Okay, thank you. Let's collect a couple more questions, and then we'll perhaps we'll try and pick them up in one go.
Good morning. Conor Foley, Norton Rose Fulbright. Question for the panel on the application to derivatives. We see, and I'm mindful, having ready access to trade repository data, we're using post-trade data for an assessment which will apply to pre-trade transparency. If there was sample pre-trade data available and provided to ESMA, would you be open to maybe re-examining some of the liquidity assessments, maybe perhaps where that pre-trade data was a little bit more illustrative of issues maybe around the margins? Just one of the concerns I think that at least our clients have been bringing to us is you are looking, of course, where transactions have been concluded. That's why they're in trade repositories. If there is pre-trade data, it may tell a different story in some cases. Thank you.
Thanks, Conor. It's interesting how many people in the audience are implying that they brought suitcases full of data with them that they're ready to share with us. again, very, very happy to have that. Let's just pick up a couple of comments then in that last round of questions. Firstly, is this the SSTI concept and how this question of retail size can be reflected. And then secondly, are we open to other sources of data in the calibration? Who wants to take the SSTI question?
Yes, so maybe on the SSTI, I mean, our approach was to come forward with something that works in practice and that it's not overly complex. So of course, I mean, our proposal now to say 50% is quite simple, but at least it is easy to understand. So if we could, I mean, we are open to consider other ways, but I mean, we're not going to come up with a table at the end listing an SSTI specific for every single instrument or for every single class. I mean, that would be really not workable in practice. So we are certainly open to look at it. With reflecting the retail size, I mean, we faced a bit the struggle that there is not much retail trading in derivatives or fixed income products. So that's a point where we said sometimes we have difficulties to understand what exactly level 1 means and how we transpose it for our level 2 purposes.
So clearly I think we're saying there's a tension between having something which is relatively straightforward and simple to understand and apply versus the comments that have been made about specific to the instrument, and we need to try and find the sweet spot, I guess, in relation to that. What about the data?
Indeed, we would be open to look at any pre-trade data that you might send us. This is one of the challenges of the whole exercise, which is how to introduce transparency in a non-transparent market. Then first you need to measure reality, and that is a challenge in itself. But it's not only in Europe. If you look at in the US, the trade system was introduced. Most of the studies that are there are not able to measure the impact of the first wave because there was no transparency before. So you have always this problem. And I would encourage you to of course, give us any data. If I would say that probably the condition is that it should be representative of, EU markets and classes of instruments, not just very reduced samples. And I would encourage you to do that as soon as possible because we have from March to June, and that's it to finish this. So the earlier the better. Yeah. Thank you.
Thank you. Lots of comments still to be received on this. Let's start on this side with the lady on the right there. Thank you.
Crystal Downs from KBC. I have a question with regard to the pre-trade transparency obligation of a systematic internalizer, especially when it concerns long-term derivatives. So if I understand the proposal well, you are only allowed to put one quote, one bid and offer quote as a systematic internalizer. But if you look at the prices now, it contains 3 elements, the professional price, the commercial add-on, and also the counterparty risk. Now, the counterparty risk, if you are only able to put one price, it means that you consider the counterparty risk as unique, which is not at all the case. A systematic internalizer remains confronted with the long-term counterparty risk for such instruments, and how can we deal with it? And if you would say we can describe it in the commercial policy, well, it's not at all. It's not good for the protection of a systematic internalizer to make all the details of its counterparty risk regime public. So we have questions about it.
So how do you take account of counterparty risk in the systematic internalizer quoting regime? Again, let's just collect a couple of questions, give a chance for colleagues to reflect and then come back. So question in the middle, gentleman in the middle there. In fact, there are 3 questions in the middle. We'll get to you eventually.
Jacob Brent-Burley from Drax. We're very happy to share our suitcase full of data. So if you are interested, then
Thank you.
Always happy to share it with you. Particularly in relation to the waivers, we've undertaken some analysis based on value traded, and we've identified that at the point 1 year after implementing the waivers, there could be a very large increase in where they're set. So the proposals that have been put out in the paper for the SSTI and the large and scale, we believe could increase dramatically 1 year after set. Was this the intention of the policy to lead to a big increase in the waivers? And for an illustrative example, across the board, we think there could be an 8-fold increase in the level that the waivers
Could
are
you just
set.
explain a little bit why you think that that is the outcome?
So when we've undertaken our analysis on value traded, the 70th percentile of value traded comes in at 8 times the 90th percentile of the trade count, and the 90th percentile of the trade count approximately lines up with the proposals which are in the consultation paper. So I guess the question is, was it intention to lead to a big increase in the waivers after 1 year, or was that an unintended consequence?
Okay, thank you. Let's take one more question, then we'll come back with some reflections. Gentleman in the middle row there.
Hello again, it's Brett Chappell from Nordea Investment Management. To come back to the question of transparency versus liquidity. My concern is that if SIs, very much what the young lady said from KBC, apply, that the price providers will be very, very reticent if they have to show a quality account, a bid, in a pre-trade transparency regime, at the same time show a hedge fund who is also classified as a professional counterparty. That instead of having this transparency, instead of having tighter bid-offer spreads in the bond market, we might end up seeing much wider bid-offer spreads. And especially if there will be forced buy-ins for people to, if banks cannot go short bonds, then we're going to find ourselves in a situation where a 10-point bid-offer spread all of a sudden, by next year, or within a few years, might be at 25 or 30. And I was wondering if you thought about these consequences, please.
Okay, thank you. So a couple of questions about the SI pre-trade transparency obligations, and then comment about the market response to the first wave of waivers and the fact that the methodology that we propose will see the waivers rise perhaps quite substantially after a year or so. Who would like to pick up the SI point? Carsten.
Thank you, David. On the SI point, and yeah, we certainly see the challenge there of counterparty risk, but we're not even doing any level 2 there. We have delivered a bit of technical advice to the Commission. The rest on the Article 18 MiFIR is certainly out of our hands. On the TREX point, I can confirm you have indeed shared your suitcase full of data with us, and we're still struggling to, compare the two sets and make sense of some of the differences we have discovered. But certainly, thanks very much for that. On the 70 versus 90% approach, if I understand you correctly, you were saying if we apply the 70% of volume, we would increase the large and scale sizes by 8 times. That is not the perception that we have looking at our data, but certainly, again, this will feature in the cost-benefit analysis, so I'm happy to look at that. But certainly from the data we are having, it's not even in all cases, or certainly not by far in all cases that it's going up at all. Sometimes we still stick to the 90th percentile. What am I forgetting here?
No, that was it. I've been given an indicative timetable for how the day should run, which indicates we should have stopped talking about non-equity transparency now. But I think this is such an important part of the proposals that I'd like to run it on for a bit. But it may just mean that some of the other things later in the day get a little bit squeezed. So if you're content to do that, then let's keep going. Question over here, please.
Good morning, Lucia Bordigato from Borsa Italiana. I have a question for Mr. Osterman regarding the coffee approach. I remember that in the last DP, you were saying that in the case the coffee approach was taken into account, the responsibility is up to the trading venue for the attribution of the asset class of specific instruments. This is not mentioned anymore in the current CP. I would like to know what were the feedbacks on it, if if you think it is appropriate to insert this kind of responsibility also in the RTS, in the current RTS. We have a problem specifically with the index-linked bond, for example. They are kind of structured finance products, but we classify them as bond because they grant the repayment of the capital. For this reason, I think it's appropriate to put the responsibility for the classification of instruments upon the trading venue.
So who has responsibility for allocating instruments to each class if we adopt a COFIA approach? Okay, let's just log that question. Lady at the back. Yes, waving her hand now. On the left-hand side. That's it.
Good morning, Anita Miller, ISDA. Just a couple of points. We will be submitting some data for you to look at and some results, and we hope you'll want to discuss them around the liquidity thresholds for interest rate derivatives. But there's something else I wanted to highlight this morning that hasn't come up yet. And then in your CP, we very welcome the question about the harmonization of the pre and post SSTI and LIS thresholds. We think it's really, really important that these things do not have to be harmonized. They can be different numbers, particularly as the risks in a pre-trade context are so high. You know, the market can move against you quite quickly. So we'll be highlighting that in our response, but I'm very curious as to whether you've had any further thoughts on that. And then just to pick up on the package transactions point, we will be submitting a proposal with some ideas about how they could be handled.
Great, thank you. So you would suggest having lower pre-trade thresholds compared with post-trade. Okay. Question over here.
Alex McDonald, WNBA. Just two comments and a question, if I may. The first comment is around the SSTI. We think it's 50% is too high, and that in part we think stems from the analysis looking at the dealer to client sizes and in the SI threshold being then migrated over to the multi-to-multi OTF framework. So some segregation, I think we did give a fair amount of data last summer towards that end. The second comment just backs up a comment earlier about the 48-hour period. We'd rather an end-of-day number for post-trade transparency so everybody understands what they're doing to a certain point, rather than monitoring some rolling number hour by hour after a trade may have been had a booking stamp on it, so that every hour there's continuing obligations. But my question is, I don't understand why ESMA has come out and segregated the match principal model to be different. I didn't read that in the level 1 in terms of not having some of the waiver treatment that other trades have. And I wonder if you could explain why sort of such an important source of bond market liquidity, you know, particularly in light of the CMU green paper we just had, would seem to be sort of carved out for being less able to operate in the way that it has done to date.
You mean for the SSTI waiver?
I mean post-trade waivers, actually.
Okay, so let's just quickly deal with that batch of questions. Who allocates the instrument to each class if we take the COFIA approach?
Yeah, we have a proposal in there, indeed, which is in the reference data technical standard to require the trading venues to basically classify the instrument to make it easier for us then going forward to put them into the right buckets, because as we said a number of times, we have data issues here, of course, and going forward, once we have MiFID 2 in place, you know, we like to have better data available to do these calculations, and that is, you know, one embodiment of that principle. Okay. What else did we have?
And then the other one question was, we have proposed that the pre and the post-trade thresholds are the same. Did we give consideration to having a differentiation?
It is a question in the CP, so if you have different thoughts on that, then of course we would take that into account. There might be some justification for if you provide some rationale and some ideas, we can look into that, of course.
And then finally, the treatment of matched principal trades. Who wants to pick that up? Okay, Rodrigo's writing that down as something we need to think about. It's the second. Carsten has a comment, though, in the meantime.
Oh, and this is again our attempt to structure like the various waivers that and deferred publication items we have to deal with. And it's not that match principle is completely excluded. We have done it for the SSTI indeed, and we are saying there, well, to be able to benefit from the SSTI, you should be, in inverted commas, genuinely risk-taking. And that's our differentiation to then also still make sense of the large in scale, because if there was no condition imposed on the SSTI, which is the lower one, there would be no point in having a large in scale anymore.
So to go back to the comment we were saying earlier, the concept that we're trying to articulate, which links the large in scale and the size specific, is to say that the thing that distinguishes them is that the large in scale is available in a sense for everybody, but the size specific is only available to those actors who are on risk. And that's how we're trying to integrate the two concepts, recognizing that when you read the level one, it doesn't quite come out quite that clearly. Let's just take a few more comments on non-equity and we then need to move on. So question in the middle, from the lady in the middle who's got a hand up now.
Hi, thanks. Elizabeth Callahan, ICMA. Sort of a two-parter. The first one is your supplementary deferral proposal that you could have 4 weeks in there for deferred publication. If you're dealing with a large trade, it often takes longer than 4 weeks to hedge a trade. And there's a lot of concern in our working group on this, that you need longer than 4 weeks, and maybe more in line with TRACE in the States. Would love to hear your thoughts if you looked into that as an option. And then secondly, a lot of conversation around LIS and SSTI, around flexibility on those. Would you consider tiering, sort of tiered approach per bond class in COFIA as a possibility? And will you be flexible to a tiered approach, or something that shows a modified to what you have in your consultation paper for SSTI and large in scale in both pre and post?
Could you just explain a bit more what you mean by a tiered approach?
In other words, like bond classes having different large in scale, different types of bond class. Corporates might be different than covered bonds or convertibles or sovereigns, and you might have a tiered LIS as a possibility. Something, in other words, throwing a bit more flexibility in there, but still keeping the spirit of COFIA as a possibility. And then they love the comment about 4 weeks to hedge a large trade. I mean, we are talking about major issues. Brett's brought up several with false positives, and I think we really need to consider that in the real economy. Thanks.
Okay, thank you. And I think on the length of the delays per se, I think we're just interested in we've put out a set of proposals. I think we're interested in exactly comments like that as to whether the proposals land in the right spot or not. I think we're open to the argument that they don't. But we need to understand why they don't. Other question? Question at the front, please.
Thank you. Ben Pott from ICAP. I just want to pick up on the point around packages. And besides looking at the treatment of packages, I was also wondering how you took account of package transactions in calibrating your liquidity and your size-specific and large-scale thresholds. I think, especially when we look at interest rate derivatives, you find that certain tenors trade almost exclusively as part of packages. So to suggest that the outright instrument is liquid, or even in calibrating the thresholds, you probably arrive at very skewed numbers. So I just wondered how you took account of that, and going forward, is there a view that if you get more information around how packages should be treated, that you would consider recalibrating either the liquidity or the thresholds to take account of this? Thank you.
Thank you. I think, as we said in response to an earlier question, I think the question about how packages are treated in the transparency regime is certainly something we want to think about. But your question is about how they've fed into the data driving the calibration. Yeah. Question right at the back, please.
Thank you. Stuart Caswell, Managed Funds Association. We'll also have some thoughts on package transactions. Two other things to raise. One is in the derivatives arena. Question about how pre-trade transparency requirements would work in voice, RFQ, and IM systems. And then the second is more of a legal question, but important. There's an emergency power available to national authorities to suspend transparency requirements, but there's no equivalent emergency power to suspend derivatives trading obligations. So we wouldn't want to see ourselves in a situation of having to trade but not have data available about what is actually going on in the market. We think those two need to be matched up. Thank you.
Okay, thanks, Stuart. The data we've used, packaged data, and then I'm not quite sure whether they were just comments or questions from Stuart, but if anybody wanted to reflect on those. Rodrigo.
So on packages, the main limitation is the source of data that we are using. So we can take them into account provided that they are bundled when reporting to a trade repository or when reporting to a regulator. If they are not, there's no way that we can identify those as packages. And probably later when we talk about transaction reporting, we might be able to tell you how we are envisaging that for the future regime. But one of the limitations we have is that the data sets sometimes allow that identification, and sometimes it's impossible to identify, to link the two legs or to the two trades of the package. If you have data that shows a different picture, of course we are interested in looking at that. On the tiered approach, I'm not sure I got exactly the proposal that you were, the lady from ESMA, because in fact we are differentiating different types of bonds, so coverts, corporates and sovereigns, they don't have the same LIS and the same SSTI. Is your proposal, well, maybe we can pick that bilateral later, but is your proposal to introduce further differentiations within each class? Okay.
We'll just have two more questions on non-equity transparency, because then I do want to move on to other topics. So the lady here, yes, please.
Hi, Kerstin Hermansson from Sweden. We are struggling with commenting on the derivatives, equities derivatives proposals, because equity derivatives trading on an exchange are quite different from the other non-equity instruments, and I agree to a large extent with what Nasdaq said before. Now the question is, from my side, what we haven't really understood, when and how can you create more subclasses than the asset classes that you now have provided or is discussed? I should say we think that the only liquid instruments as equity derivatives is index derivatives, if you look at the classes as now provided. But will you and can you also set subclasses?
Okay, thank you. I think we have flexibility to change the classes. We obviously put out an approach in the discussion paper, which I think seemed to find general acceptance, and we've developed the more detailed transparency proposals around that way of segmenting the marketplace, but it's not the only way of doing it, and we could change the classes that we've proposed reasonably easily, I think.
Yeah, and certainly if you look at bonds, but even more so interest rate derivatives, I mean, we have built loads and loads of subclasses there.
Okay, final question on non-equity from the lady in the middle here.
Hi, Miranda Morad from Market Access. My question is about the information to be made public on an RFQ. We're also struggling to help come up with a proposal. It's not really one that can be backed up by data, but more by principle. So my question is this. You've got two provisions in the level 1 text. The provision to make quotes, bids and offers public, and also the provision not to expose liquidity providers to undue risk. So which is more important, which is paramount between those two?
I think Carsten will say that all aspects of legislation have to be complied with.
Of course.
Let's move on to the final segment before. I think that probably is what Carsten would say, actually. He's got a very dry English sense of humour, has Carsten. Let's move on to the final topic before we take a coffee break, which is just to cover off the double volume cap and Article 22 of MiFIR. And Erika Conta has been leading on this. Erika.
Thank you. Good morning, everyone. RTS number 10 defines the content, format, the frequency, and the time to respond to data requests that trading venue, CTPs, and DAPAs will receive from competent authorities in the future under Article 22, whenever they have to carry out the calculation for determining the requirements for pre-trade and post-trade transparency, the trading obligation, for determining and assessing if an investment firm is a systematic internalizer, and last but not least, to provide ESMA with the necessary information to produce the reports for the monitoring of the use of pre-trade waivers under the double volume cap mechanism. As you know, this is a sensitive task, and there are potential commercial consequences out of this. So we need to make sure that the calculations are accurate and done in a timely manner. In this regard, ESMA proposes to collect data from two different data sources, trading venues and CTPs, in order to validate the accuracy of the data, to collect data twice a month, in order to minimize the errors, and also to be prepared for the publication around the middle of the month, whenever the threshold of 3.75% and 7.75% are reached. Also to collect data related only to the last 15 days in order to reduce the burden of the data collection. And last but not least, also to publish the reports on the ESMA website, free of charge and in a readable format. So these are,
Thank you very much indeed, Erika. This is essentially an area of practical implementation. The policy content is really in the level 1. We just have to give, well, not just, but the primary focus of our efforts is to give practical implementation to it. But just to see what comments there are on this particular element of the CP. Anybody have any comments on the double volume cap or the broader data collection implied by Article 22? No. Okay, fair enough. In which case, I suggest we take a coffee break then. You've earned a break. Let's come back at 11:15. 11:15. We'll start at 11:15 prompt. I think coffee should be somewhere outside. I don't know whether it's on this floor or downstairs, but I'm sure it should be reasonably visible without too much effort. So we're back in here at 11:15, please.
Yeah, must be good.